Hey, folks, and welcome to the update you deserve. Attorney Steele bringing the receipts. Now, I will do a full stream on this on Friday, where we'll go through all the interesting things that happened during this break in proceedings in the Youngstown trial. But this week I have had so little time to do it, so I will do a full stream, 5, 6, 7 hours on a Friday. But today I'm invoking my inner redneck to bring this to you. Okay. Welcome to the show, folks, and let's bring this up. Now, Judge Glanville really don't want any at all insight into the ex parte meeting, what happened in it, what was said in it. He still claims some kind of privilege. And Attorney Steele, yeah, it's so good to see. I mean, it's lawyer heaven. Well, it's not, because in lawyer heaven, Judge Glanville wouldn't be presiding. But let's listen to this, and I will try to. The sound here, Brian Steele, quite low. Judge Glanville talks into the microphone, but we will try. Just listen to this.
Camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's reserved, but Mr. Williams would like to be present.
Yeah, you told me that already. Do you have any additional case law other than the United States Sixth and Georgia's Sixth Amendments?
Georgia's Article 1, Section 1, Paragraph 12. I believe Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you all are here just for in camera, that's attorneys, because
in-camera hearing with attorneys only. Do you know what that is also called? Ex parte meeting. Judge Glanville does not want any of the defendants, only their lawyers. And his reasoning is so flawed, it's ridiculous. But let's continue.
Because of the privilege potential that is that may be discussed, or no, I said not discussed, identified, and you all as lawyers are of course subject to the rules of professional responsibility. Third parties or your clients and other people are not.
okay. Well, I oppose that objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, I will when the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment.
Judge Glanville, you should not be the one determining that, because you were in that meeting. You shouldn't. There's no way you should. You are a witness in that for the defense in the coming, hopefully as soon as possible, Georgia Supreme Court will take this particular issue up. But the way that Judge Glanville keeps trying to avoid accountability for this absolute major fusterclock it's appalling. And by now, he knows this, but it keeps going.
And then I will flag all those, and then anything else that you all wished for me to consider, you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence and in open court.
Okay, I don't think he can do until I identify it, Mr. Steele, and make rulings on it. He doesn't have the right to be present. You're the person that's present for him at that point in time because it covers privilege. It's just.
Here he goes again. Now he's getting annoyed because this is a crucial part of this trial where the judge is actively trying to not have possible exculpatory evidence brought to the defense and definitely not in front of the jury. Now is Mr. Steele, well, let's just say he brings the receipt.
It's like if you had DFAX records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are appropriate, and I will make other rulings in regards to sealing that particular portions which are not for any other review, and then you can take that to Mr. Williams, and all of you can talk about that.
I understand. I just
I know you've made an objection as to that, as to your client's presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but
I understand that we are in disagreement, but I'd also like to then, an open courtroom, I believe that it should be done in open court as well, and that's under Article 1 and
okay.
the first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in camera. That doesn't apply to an open courtroom. The in camera review of these records. So we'll just, like I said, if you got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions of the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay. And then we will have the rest of whatever we have in open court. Okay.
Understand the ruling.
Okay. All right. Like I said, if you have some case law you want me to look at something, I'll certainly look at it because I
believe that under,
Judge Glanville didn't think Mr. Steele had case law. Mr. Steele is a very good lawyer. Let's just say that.
United States and Georgia Constitution expressly, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers, jury room.
You are correct about anything else, but when you're dealing with a matter of privilege and or depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for. Because I have to make a determination of whether or not first you get it and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why.
And Mr. Steele, let's just say, we already know Judge Glanville is morally corrupt and should be thrown out. In my opinion, said it before, I will say it again, Judge Glanville, the only time you should be authorized or allowed into a courtroom is if you are the defendant. But let's continue listening here.
Or else I give you the entire transcript. It would be fine for me, but I think that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on transcript with the court present, it can't be attorney-client privilege.
Well, that's for.
It is that easy. It is that easy. If a conversation between the attorney and the client is transcribed, written down, caught by the court reporter, and is in a transcript, there is no attorney-client privilege. Why? Because this was an ex parte meeting with Judge Glanville, the prosecution's team, court officers, investigators, everybody except the defendants and their attorneys. And there's a transcript. There is a transcript. We know that now. And there is no exception that Judge Glanville can apply to this. He knows it, but he refuses to acknowledge it because he's morally and judicially corrupt. He made a huge mistake in doing this ex parte meeting. And now he knows. That is why he's trying to push it forward until after the trial.
Another body to resolve, not me. And you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation again, because that will affect whether I seal it or not.
That's fine. I'm just continuing. I voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you've got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny, P-E-N-N-I-E versus State, Sammons, S-A-M-M-O-N-S versus State, Ward, Wade, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right to public trial.
I understand that, sir, and I'll take a look at the cases you cited, and that is part of what the court has to rule upon whether or not it was in fact.
Yes, the attorney still brings the receipts, but this is basic trial knowledge, not basic knowledge around trials. Judge Glanville has been a judge for decades. He knows all this. He knows it. He just refuses to follow the law. Simply refuses to follow the law. Now, luckily for all of us is that the Georgia Supreme Court, when they brought the hammer down on former Judge Christina Peterson, one of the subjects they really hammered on was her misconduct in an ex parte meeting, and a criminal contempt ruling. The Judge Peterson case in the Georgia Supreme Court was a de novo case, as in fresh. We see it with fresh eyes. And now, with that, they have a precedent which can be applied to this situation as well. I assume and I hope that the Georgia Supreme Court will bring this in the next couple of weeks before before Woody ends his testimony. And then we will probably have a mistrial. Maybe even a mistrial with prejudice because of the horrific conduct of the judge and the prosecution. But we're not there yet, but we will get there sooner or later. Thank you for listening, folks. Check out my other content and hit the like button on your way out. Okay, folks? See you around. Bye-bye.